Good evening to all. Just a small audio check before we start. Till then, you all can share the link with all your friends because I will complete the entire charges chapter along with the past exam questions and ensure that the sections are memorized and you become a master of this particular topic, and any possible question in your exam has to be framed from what we are doing today because we're going to do every single thing including the depth. Okay, good to go. Can we start? Yes. So firstly, about the dream batch for CS executive, I've created it. For the upcoming exams, you need to go join this batch. I will be personally monitoring this batch. Okay, you need to download the Jahangir Tutorials app. The Apple users need to download the Class Plus app and then put the organization code IEA PQ. Moment you do that, there will be a plus sign. You need to add click on the plus sign and you need to add the batch code dream batch exe. Moment you're done, you're in the batch along with hundreds of students, and I will be monitoring them along with the revision lectures as well. So today's classes, today's lecture is about charges. I want all of you all to keep your study material, whatever topic you have from where you're studying. I will be covering the full topic. The sections will make you a master in this particular topic as well. Okay, now charges. First, whenever we do anything under the company law, we need to know where is the section, what chapter it is covered in, what are the name of the rules. Basically, we should know what is the provision under law. All of y'all need to take a screenshot or write it down with me. Okay, so the charges 100% definite question in your exam. The definition is given of charge in section 2 subsection 16. The provisions are given from section 77 to section 87 and your chapter 6 of the Companies Act. The rules are given under the Companies Registration of Charges Rules 2014 and the forms are from CHG 1 to CHG 10. You think you will be able to remember and memorize all the forms? Wait till the end of the video. You will be a master of all the forms and will be knowing all the sections on the tip of your tongue. Okay. Now, let's understand the concept of charge. Okay. Now, let's understand. Today, when companies require funds to function, yes or no? Companies require money to function, run their businesses, yes or no? This money can come from two sources. One is own funds, companies, the equity shareholders, the shareholders contribute their own money. Business owners bring in their own money. The second option is borrowed funds. Borrowed funds is when we go to banks, financial institutions and raise money. Now, whenever we raise money, do you think the banks will be giving loans without securities or banks normally give secured loans? So, whenever you have banks and financial institutions, they are ready to fund companies, they are ready to give this money to the companies, but in return, the borrower needs to keep some asset as security. This is the security that the companies have to keep, okay, called as security. Moment I get the money, the company gets the money, they keep their assets as security. Can the company now sell the assets? Can the company dispose of the asset, deal with the assets, or you think the bank will have control over these assets now? What do you think? You think the bank is going to allow me to sell a secured asset? Answer is no. The bank is now going to be called as a charge holder. They are going to have they are going to be called as the charge holder. Charge in normal, simple, basic language can be called as they have a control. They have certain rights over the property. So till the loan is not repaid, the banks, the charge holder will not allow you to sell off the assets. So what is a charge? A charge is actually a right the borrower creates to get a loan. So the borrower today, when we want to take a student loan, we go to the banks, we give the bank the rights that if we don't repay, you sell off this asset. So we are giving the rights to the lenders, and the lenders are getting control. And the reason that they're getting control is because they have given money to us. Okay. So concept of charge clear. Now in your company law, if you go to see under section 179, okay, to be more specific, subsection 3D gives the powers to the board of directors, to the BOD, to borrow money, So what happens? The board of directors pass a board resolution, go ahead and borrow the money and keep the assets as security. So a loan is very simple to take just by taking a board resolution. But do you think that the board of directors can take unlimited amount of loan? Or you think there is some restriction under the Companies Act on the amount of borrowing that you can do? Anyone knows can put in the chat box what is the maximum amount of loan or that the board of directors can take? It's an interview question. They call what is the borrowing power of the board? Explain. So the answer, anyone wants to try what is the maximum amount the board of directors can borrow? So the answer is given under section 180. So here they give you the powers. Company law gives the board of directors the powers. By the very next section, they create a restriction on powers of board of directors. So they have put a limit. Beyond that limit, if you want to borrow money, you need to mandatorily take a special resolution of the shareholders. Concept clear? Yes. So how much is the limit given here? So it is your 100% of your paid up capital plus free reserves plus security premium account. So what is this? This is the maximum amount the board of directors can borrow. It's a borrowing powers. So we will calculate what is the paid up amount. We will calculate what is the free reserve the company has. We will calculate what is the security premium that the company has. That's the maximum amount the board can borrow money. Beyond that, if the board wants to borrow, they have to go and take a special resolution from the shareholders given under section 180. Now, so this is nothing but like a mortgage. Now let's go to the definition. What is given? This has to be quoted by every single one of y'all in the exam. The definition. Definition is given under section 2 subsection 16. Charge means an interest or a lien created. Now interest means what I told you. We create a right. The borrower gives the right to the lender that if I don't repay the loan, you sell it off. I'm giving you control. I'm giving you rights. I'm transferring my interest to you. So now the borrower, the companies nowadays, they transfer these rights. They keep their property or assets as security on any of its property, assets or its undertaking, and includes a mortgage. Now understand what is this. So what is a charge? A charge is nothing but a interest. Interest means a right or a lien. I give the power. So this is created on the property of company. Company's property I create. Now what kind of property do we have? We can have assets. We can have various kind of undertakings also. So basically if I have my business unit can also be kept as security, that if I cannot repay, I will transfer this business to you. So that undertaking is a business unit that I can also keep as security, that if I can't repay the money, my airline division, I will give it to you. Okay, and includes a mortgage. Now, very interesting point, I don't know whether you must have noticed this. Can you tell me, charge includes a mortgage? So which is a wider term? Charge is a wider term or mortgage is a wider term, and what is the difference? So can you all tell me which is a wider term? So let's understand. Okay, now we have charge includes a mortgage. Now see, charge can be created on movable as well as immovable property. Immovable property. Whereas mortgage can only be created on, mortgage is only created on immovable property. Clear till here? So again, charge includes mortgage because whenever we keep a immovable property as security, it is a mortgage. But charge is a wider term. So charge is a wider term. It includes movable property also. So I can keep my my stock in trade goods as security. I can keep a car as security. I can keep my godown goods in the godown as security. Datas can be kept as security. These are all, shares can be kept as security. Something called as pledging. So all of that is movable property can also be kept. Immovable property can also be kept. When immovable property is kept as security to take a loan, it is called as mortgage. Clear till here? So charge is a wider term. Now, so charge is nothing but a right created in favor of the lender on the assets of the borrower as a security for repayment of the loan. So the borrower says that I'm giving you this right, but when I repay it, then the right is over. So the lender is a charge holder and the company here is the borrower. So now, as I told you that section under company law, once we've understood what is charge, charge is nothing but keeping assets as security to take loans. That's it. Okay, very simple concept. Now when we keep assets, assets could be movable or immovable also. Now charges are given under section 77 to 87. Now do you need to remember all the sections? It's very good if you can, but at least the important ones we should know. That's your section 77, 82, 87. Three important sections. Section 77, it has 4 subsections. 77, 1, 2, 3, 4. All 4 we will do in depth. Section 82 and 87. Let's understand now. Whenever we create a loan, whenever we keep assets as security, it is said that we've created a charge. Moment on creation of charge, I have to go and inform the registrar of companies. So registration of charge is covered under section 77. Let's take an example. Okay, so we have a company ABC. Okay, this company has an asset, it has this building. Okay, this building, it wants to keep it as security. They go to bank, okay, they go to HDFC bank and they say, please give us a loan of rupees 1 crore and we will keep our building as security. Can you tell me, is a charge created? Yes or no? So a charge is created. Moment the loan documents are signed, a charge is said to be created. Moment you create the charge, the bank gets control over this asset. So they will be called as a charge holder, the controller. Okay, and this will be the borrower. Simple. Now when a charge is created, that means the loan is given and all the documentation is done. Companies in India have to mandatorily inform the registrar of companies. So all of them have to mandatorily go. So companies will have to go and inform. So there is the lender, there is the company. The company has to go and inform the registrar of companies, because in India, the registrar of companies should know exactly how much loans have been taken by companies, all the details, and to ensure that there are no disputes with respect to this. So law has been made that moment you create a loan, or the documentation is complete, come and inform us. Clear till here? So that is called as registration of charge, has to be informed to the ROC, section 77, within 30 days of creation of the charge. Now moment I create the charge, tell me one thing, these loans are for smaller time period or long time period? These loans, if you've seen, these are 10-year loans, 20-year loans, 35-year loans. So during that time period, it is possible that there is some changes in the original terms and condition, yes or no? So in the original charge document, it is possible that the amount has been changed, loan has been restructured, schedule, the time schedule must have changed, interest rate must have changed with the agreement of the parties. All of these changes are called as modification of charge. Modification of that is changes in the original charge document also have to be intimated to the ROC within 30 days of modification. Next, what do you mean by satisfaction of charge? Now satisfaction, let's say the charge has been created after the tenure is over, 35 years are over, and the loan has been repaid. That is called as satisfaction of charge. So what do you mean by satisfaction of charge? It means repayment of the loan amount is called as satisfaction. Again, you need to inform the ROC. That's the closing. Perfect. So both when the banks nowadays, I'll tell you on the practical side, what happens the moment the charge is over, the banks normally give a NDC certificate, non-due certificate, or a NOC, that yes, you have repaid the loan, now I don't have any rights over your property anymore. So whether it's a registration, creation of charge, whether it is a modification of charge, or whether it is a satisfaction of charge, you need to inform the ROC. Clear till here? And there is some time periods. If within that time period you cannot go, then the central government has the power to condone the delay. So we'll see what is the the maximum time limit within this intimation should be made. If within that, if not done, then you have to go and inform the central government. Clear till here? We will see. Now this is important. Okay, the timeline. This is the current present day timeline. First thing, all of you will have to message within how many days of creation of charge do you have to inform the ROC. So you have to inform the ROC within 30 days of creation. Clear? Within 30 days of creation, I inform the ROC and register it with the normal fees. Second, if I could not file it within 30 days for whatever reason, then the law says that up to 60 days from creation of the charge with additional fees. So again, up to 60 days from creation, that means more 30 days delay is allowed. So if this is the creation date, if you have created from your 30 days you need to register it with normal fees, then you get more 30 days. Collectively they are talking about 60 days from creation with additional fees. If within that also you've not done, within 60 days you couldn't inform from creation, then a further period of 60 days is given, further 60 days. Okay, and here the fees will be taken is on value, ad valorem fees. Now what is ad valorem fees? On the value of the loan. Imagine how high that will be. So one is normal fees you have to pay. For this delay you have to pay additional fees. For this delay you have to pay more fees, that too on the value. Now they have capped it up. We will see what 1 lakh or 5 lakhs. They have capped it that beyond this fine you don't have to pay on the ad valorem fee. So total, can you all message me how many days delay is permitted? When you calculate all of this, how many days delay is permitted? 30 plus 30 plus 60. So today, nowadays, companies normally they ask us how many days till how many days delay is permitted. So the answer is 120 days delay is permitted. Beyond that, nothing can be done, and the charge holder will be treated as unsecured. We'll see, this charge will not be registered and it cannot be registered. So maximum time period within 120 days it has to be registered. Next. Now this was after 2019. Before 2019, which is not important for us now. Okay. So now this was the timeline before 2019. So this is outdated, like the earlier time period. This is the after 2019 amendment. This is the timeline. So 30, more 30 and 60 is what we have to remember. In short, I will just tell you before 2019 how it was. It was 30 days with normal fees. Then you get within 30 days of 300 days. So 30, 300 from satisfaction, additional fees. And then after 300 days, it was condonation from central government. So first timeline was always same. Within 30 days of satisfaction, you had to inform. Second, 300 days. Okay. So this was for registration of charge after 2019. Again, sorry. This is for satisfaction of charge. One second. This is for satisfaction of charge within 30 days. Then more 300 days is given, and after 300 days you can get condonation, that is pardoning from the central government. So for registration and satisfaction, the timeline has been given. We will see in a short while in depth also. Now, very important, the forms, all the 10 forms that we need to know. First, CSG 1. Now, moment you have created the charge, I have to go and inform the ROC. I'll inform in a specific form, that is an application for registration for creating or modification of charge. This is for other than debentures. If it was for debentures, then it will be in CSG 9. Now CSG 9 is for creation or modification for debentures. Let's understand what is this debenture part. First, very important, have you heard of secured debentures? Yes or no? Have you heard of secured debentures? So what happens? Companies prefer to take loans. Company can go to the public or the smaller people. Company issues debentures, give these people called as the debenture holders. Just like a share, you get like a bond, how it is there, like this, on the face value will be there, interest will be given regularly. Okay. And so company issues debentures to them, and they then give funds to the company. Now these are also creditors of the company. They are also lenders to the company, right? They get interest, etc. Just like how a loan is there. In loan, you take from HDFC Bank, one person, a huge amount. Rather, companies can also choose to go to a larger number of people and take small amount of loans from them and give them interest. Now they are also like the banks, like they are lenders, they are creditors. To secure their interest, to secure the interest of these debenture holders, company can keep some asset as security. They can keep this asset as security. So again, when this asset has been kept as security, it will be called as creation or registration of charge. Clear till here? Again, you go and inform the ROC. But since it is related to debentures, it will be in CHG 9. Concept clear? So CHG 1 and CHG 9 is for registration or modification of charge. Now moment you apply, so the company gives to the ROC, okay, so the company goes to the ROC for registration of charge. They file CHG 1. ROC will then issue a certificate to the company that congratulations, your charge has been successfully registered. So ROC gives a certificate to the company in CHG 2 that congratulations, your charge has been registered. This document is the most important document that is covered, okay? Most important document. Why? Because moment CHG 2 is given, I know that my charge has been successfully registered. So CHG 2 is a certificate by ROC to the company, telling the company that yes, we have received your application and we have successfully accepted it, and this is the certificate. Okay. For modification, certificate will be issued in CHG 3. In one, application is made for registration and modification. So it is one form for two things. For registration and modification, same thing. But a certificate in CHG 2 and 3 is for registration and modification. This is for certificate for registration, this is certificate for modification. Now, this is creation and modification. The third important term I told you to know is satisfaction. Now, satisfaction is when the charge has been successfully repaid, loan has been successfully repaid. So CHG 4, we'll have to again inform the ROC in CHG 4 saying that we have successfully paid off the amount. ROC will issue a certificate in CHG 5 that congratulations, your charge has been successful, that satisfaction of charge has been registered with us. Now we know that the loan has been repaid. So this again is by the company to ROC, and certificate is by ROC to the company stating that it has been done. Now tell me, this is a happy ending when you have repaid the loan? Yes, loan has been repaid, there is a happy ending. But is it necessary always that there will be a happy ending? Answer is no, there can be a sad ending also. And when I say sad ending means what? The loan could not be repaid and a charge holder, a receiver, manager, liquidator was appointed for that property. That XYZ person, like how we saw in Vijay Mallya, Nirav Modi, so many cases where Anil Ambani, whether Subrato Roy, Sara owner, all of them couldn't repay the loan, couldn't repay. So then a liquidator is appointed to liquidate, sell off the assets and recover whatever amount is there. So that will be in CHG 6. So it's a sequence. 1 you apply, 2 and 3 you get the certificates, 4 is satisfaction, 5 is a this, and 6 is a sad story. Now all of this, CHG 7 you have to maintain a register, CHG 9 you've done. Now talking about CHG 8 and 10. Both these forms are intimation for delay, that sorry we were delayed. This intimation is to central government that there is a delay or some rectification is needed. Application by the company for delay or some rectification to the central government is in CHG 8 and to the registrar is in CHG 10. Concept clear? All the form numbers you should know. Now again, very simple short story. Need for creating of charge. Obviously companies borrow funds, they require funds on day-to-day basis. Sometimes they go for own funds and sometimes they prefer taking some part as loan. Now section 77 we are seeing, now we'll go section wise under the Companies Act. Section 77 subsection 1. Whose duty do you think it is to register the charge? Whose duty it is to go and inform the ROC? Obviously the company has to do all the compliances. So the company's duty is there to go and inform the ROC that we've created a loan. So it is a duty of every company who is creating a charge, whether in India or outside India. So nowadays we have many MNCs, multinational corporations. You go and see Tata's has a property in Europe. Asian Paints is listed in US. So they can have assets abroad. So I can choose to keep security assets in India or assets abroad. So if a company is keeping assets anywhere in the world as security, they have to inform the ROC on any of its property, assets or undertaking, whether tangible or intangible. Now tangible, I can understand properties which you can see and touch, like plant and machinery, land and building. How do you keep a intangible property as security? Now obviously nowadays software are also assets, know-how, royalty, all of this, some rights that you must be having, authorship rights, all of those can also be kept as security. Goodwill can be kept as security, which are intangible. So I'm talking about IPR, intellectual property rights, can also be kept as security, and availed loans, patent rights, etc. can be done. Okay, now to register the charge and signed by the company and the charge holder. So the signed documents need to be done in CSG 1 for forms other than debentures and CSG 9 for debentures within 30 days. So if you go to see duty to register the charge, it's a duty of every company to register the charge, whether you've created in India or outside India, whether on any of your property, whether it is tangible or intangible, and CSG 1/9 and within 30 days of creation or modification. Concept clear? The timeline I gave you, that delay in registration of charge before 2019. Now again in 2019 there was changes in the timeline. So we are going to see what was there before and what was there after. We are obviously concerned today what is the timelines given after 2019. So after 2019, I'll just take you through quickly. This is important for us. This is what you have to pay attention to. So I'll go through this first. First, remember I told you that the registrar may allow, now this is a delay, okay, may allow in case the charge is not done within a period of 60 days from creation on payment of additional duty. If it is not made within 60 days of creation also, then within a period of 60 days from ad valorem, by paying ad valorem. So this is your timeline. You can take a screenshot. 30 days from creation, more 30 days delay is allowed, but you have to pay additional fees, and further 60 days is allowed. So a total of 120 days is maximum allowed. And if you notice that there is no option for condonation of delay with the central government beyond the point specified under section 77. So in your entire Companies Act, beyond 120 days, there is no provision on what you can do. So it means that the companies don't have any provision to register a charge after 120 days. So all the consequences of non-registration of charge will apply, penalties, etc. Now 30 days, further 30 days and 60 days, total of 120 days from creation. Okay, now if you go to see what was there, the timeline before. Now before is what, was there before. It's not important for now, but I'll just take you through the timeline, which is also very simple. 30, 300 and within 6 months from the Companies Amendment Act 2019. So what was the timeline before? Within 30 days of creation was always same. They had allowed more 270 days delay was allowed. So 300 days from creation, that is 270 days delay was allowed. And then moment the Amendment Act came, it says within 6 months from the Amendment Act, you are allowed to register it. After that, all of them will be rolled over into the new provision after 2019, that is max 120 days. So 30, 300, and moment the Amendment Act came, more 6 months were given. Within that you have to register. After that, all of them will be rolled over into the new provision. Clear? Now going to the next one. one interesting line is there. I want you all to interpret and tell me what you all mean. Okay, some little bit amount of skills, legal skills, reading skills, etc. Subsequent registration of charge shall not prejudice prior charge holders' rights. Now, what does this mean? So, obviously, all these terms are very technical, but let's make it simple. Okay, any subsequent registration of charge shall not prejudice any right already acquired in the property. Can you all message in the chat box what you all feel that this sentence means? Okay, it's an important line, very interesting line, and practically also very important. So you all can start drafting what you think means with this. I will read your comments. By that time, let me put out an example for you to explain this situation. First, this property is there. Okay, this property is there. It is worth 10 crores and up. This property the company kept as security to bank 1 for 1 CR. Now this property might be 50 crores. Till here it is clear. Company has a building which is of 50 CR. They kept this, they took a loan of 1 CR and kept it as security to bank 1. Second, they realized we need one more loan. Let's go to bank 2. Bank 1 was not ready to give. So we went, kept this same property as security to avail another loan and to bank 2, and I took another 1 CR loan. Possible or not possible? Now obviously, since the first amount was very low, the property value is very high, a subsequent charge, a subsequent means a second charge, later on. So a subsequent charge can be created on the property. Okay. Now, will this subsequent charge, the second charge, affect the rights of the first charge holder? Should the first charge holder get scared? Answer is no, because law is saying that any subsequent charge, later on charge, shall not prejudice, that is affect, wrongly affect any right already acquired in the property. So bank 1 has already acquired the interest in the property, so it will not be affected with any subsequent registration. Concept clear? Now coming to the next one. So this was section 77 subsection 1, which spoke about CHG 1, CHG 2. Now coming to CHG 1. Now coming to section 77 subsection 2, which talks about certificate. So in 77.1 I apply, in 77.2 certificates is given. Certificate of registration in CHG 2, certificate of modification in CHG 3. Now subsection 3. Now what does section 77 subsection 3 talk about? Liquidator shall not take into account charge unless certificate received by ROC. Okay. Now this is a statutory legal restriction on the liquidator, that if any lender is coming to you and saying that he is secured, ask for CHG 2. Ask for CHG 2. Ask him where is CHG 2. If you don't have CHG 2, means ROC has not given you a certificate, then liquidator shall not consider you as secured creditor. I will treat you as unsecured only. Clear? Again, there are many cases which I will come through it also. So if imagine I don't have CHG 2. I don't have the certificate that government, that ROC has issued to me that my charge has been successfully registered. So can liquidator say that no, I agree that you are registered? So answer is no. No charge created by the company shall be taken into account by liquidator. So telling the liquidator only, don't take into account any charge unless it is properly registered. Fair enough. So we are telling that there is no safety for you if you don't register the charge. So better go and register the charge. Section 77 subsection 4, obligation for repayment of the money is unaffected. Now just because a charge was not registered, does that mean, okay, so let's take an example. There is this company and there is HDFC Bank. Okay. Now you read the provision and tell me. I'll ask you the question. We'll read and explain. Okay. So this company kept this security. They gave all the papers, but security, but did not register. Didn't register the charge. And in return, the bank gave a 1 CR loan. Now the timeline got over, 120 days got over. Now liquidator should not, because since CSG 1 was not filed, CSG 2 was also not given. So HDFC Bank went to the liquidator, treat me as secured. Said no, sorry, you don't, the charge was not duly registered, I cannot do. So tell me one thing, this company started laughing. Company started laughing, saying now we don't have to give 1 CR only. Does the obligation to repay the loan gets affected? So here they are saying in subsection 4 that listen, he is not a secured creditor, the security is not registered, but the obligation to repay, the duty to repay the loan on you is always there. You always have to repay the loan, and you will, and this person will not be treated as secured but unsecured creditors, and unsecured creditors also can obviously recover the money, right? That is there. Next is very important, consequences of non-registration of charge. For example, if a charge is which was required to be registered and it is not registered, so what will happen? So first thing, the line is it will be void against the liquidator and any creditor of the company. What is the line? It will be void against the liquidator and the creditor of the company. So first, the liquidator cannot treat the person as a secured creditor. So it is void against him. Even the creditor cannot ask for preferential right or cannot ask for security or cannot be treated as a secured creditor. So they say void against the liquidator means at the time of winding up, the liquidator cannot treat this person as secured. And void against the creditor means what? Even the creditor cannot be treated as cannot claim any rights. Now, I'll give you an example of this, very, very interesting. Okay, now pay attention. Now, if a charge was created, so this property was there, we created a charge to bank 1, okay, but didn't register. So bank 1, we had taken a loan of 1 CR, kept this property as security, but did not register. Okay. Now since I did not register, obviously they will not get any rights. What I did is I went subsequently, later on, after few days, to bank 2 and I took a 1 CR loan and I registered this charge. Can you tell me who will get priority at the time of repayment of loan? Bank 1 or bank 2? Who will get priority? This guy was not registered with ROC, but this guy was registered, but this was done later on. So obviously this bank will be treated as secured and will get priority, and this creditor will not have any rights. It will be void for him to go and claim any rights. So what is this line, the sentence? That if any subsequent charge has been created and registered, then the subsequent charge holder will be treated as a secured creditor and will get priority over the unsecured creditor. Clear? This was an important case law. I want you to highlight, mark it in your books as well. Ambika Mills, where in Ambika Mills the company couldn't prove, the creditor ONGC was a creditor, couldn't prove in front of the liquidator that the certificate was given or the form was filed. So because of that, ONGC was treated as unsecured creditor. Okay. Now, coming to section number 78. Can you tell me one simple thing? Who will get affected the most if the charge is not registered? Whether the company or the charge holder? I want you all to message, think and tell me. Think and tell me in the chat box who will get affected. Whether the CHG, whether the bank will get affected or the company. Whether the lender will get affected or the borrower will get affected if charge is not registered. Okay, who will get affected if charge not registered? Who will sit and cry a lot? I want you all to put in the chat box. Okay, who will cry? So obviously, correct, it is the lender who will cry, not the borrowing company. Not the borrowing company, it will be the lender. Why? Because the lender, the bank, HDFC Bank, is now going to be treated as a unsecured creditor, right? Borrower, very nice. Security is also not kept as, is not under any control now. So the lender will cry. So what law has made that under 77, they told that it is a duty of the borrower, that is the borrowing company, to go and inform. But the lender started saying that why will he go? He will get the benefit if it is not registered. So it is possible that the borrowing company start delaying. So then this was not there in 1956 Act. They introduced it in 2013 Act, where they said no, let's give the lender also a chance to go and register if the borrowing company is failing to register. So a right has been given in the next section, 78, in section number 78, that if the borrowing company is not going, then the lending entity can make the filings and recover the cost from the borrower company. Makes sense? Yes or no? So where the company fails to register the charge within the set time period, a person in whose favor the charge is created may apply. So in whose favor, that is the charge holder, will file to the ROC the specific forms. The registrar will give a notice to the company. Now obviously, if the lender is coming, then the ROC will not just register. They will ask the borrowing company that this person is saying he's given you a loan. Is it correct? This is the amount. So they will ask for feedback, and and whatever charges has been incurred by the lender for filing can be recovered from the borrowing company. Now section number 79. So 77 super simple, 78 simple, now 79. Now 79 has a very interesting concept, but I don't think many people understand this section. What it says, the provision of section, so I'll read it plain and I'll ask you a question. The provision of section 77 relating to registration of charges shall apply to a company acquiring any property subject to a charge or any modification in terms to the extent of operation of any charge registered. So this is section 79. Have you understood? Legal language, little difficult. What does it mean? The provisions of 77 shall apply to a company acquiring any property subject to a charge or to modification. What do you think? You all need to type in the chat box or in the comment section. I will read it up and tell if it is correct or no. Okay? Correct. So let's see. Let me give you a illustration for this. Now, first, if there is CHG 1 has to be filed whenever there is a creation or modification of charge. Yes or no? At least this much you all get message. Modification of charge. So if you all tell, then I'll understand whether you have understood till here or no. CHG 1 is for creation or modification of charge. Now, yes. Now what happens? Understand. If for some reason there was the bank that was the creditor, and this was the borrowing company. This was the borrowing company. Now there is some modification. That means few changes that has occurred in the original terms and condition, original charge document. There must be some changes. So again, the timelines which are there is same, which was for registration will also apply for modification. 30, 60, total 120 days, remember. So whenever there is a change from that day, again the 30, 60, 120, that entire 120 time period will apply. So let me give you an example where they've given us property subject, to a charge, etc., acquiring a property. Let's understand the nature of modification. Now understand what I'm saying. What happens nowadays, there is something called as asset reconstruction companies, ARCs. And in India, the biggest ARC is ARCIL, Asset Reconstruction India Limited. What happens is, this bank, realizes that it's a 35-year-old loan, 35 years. Might as well I transfer my rights to a company, to another entity called as, these companies who buy these borrowers are called as securitization companies or asset reconstruction companies. Some call it as special purpose vehicle, etc. So what happens? Banks say that, see, I am getting regular cash flow. I will get total so much. I am ready to give my rights. You give me some amount here and that's it. You are in my place. So if it's a 3 crore loan, they will say that you just give me a little bit money. I require money now. You give me 2.5 CR, that's fine. 0.5 CR will be your gain. So here what is happening, this charge holder is now transferring his loan. For example, if there was someone supposed to pay you, but he will pay you a small amount over 35 years. So you can come and give me a lump sum amount. You come to me and you say, give me a lump sum amount, and he will now pay you. So then what happens? There is a change in the charge holder. So this becomes the new charge holder. Concept clear? Now this will have to make all the payments to them. So this is the new charge holder. So isn't this a modification? So this is also a modification in the original charge document, where the lender in between the time tenure is stepping out because he's got some funds from someone and he's telling the balance amount you pay to this new guy. So this is also modification. This also needs to be intimated and the new documents need to be filed of CHG 1 by the new charge holder. Why? Because this new company is getting property. All these assets which are there now, this assets control, this will get, he is getting property which is already subject to a charge. Clear? So modification, it will apply. Yes, companies can take loan again on the same property, no issue. Now, so what happens here? The securitization is a new company that is come in. It is acquiring property which was subject to a loan, and then we are taking it. So again, they need to make all the filings done. Another example I will give you for the same topic. Let's say there is a takeover. Company A has taken over company B, and this company B had certain loans which were secured, etc. Now all these assets were there. These assets are subject to a charge, and the owner is changing. So whenever there is any kind of change, mergers, amalgamation, one company takes over another company where the assets are already subject to a charge, So for example, if there is a company, Jet Airways, it got taken over. The assets were already subject to a charge. So the new person who is getting control has to make the filings. Now read. The provision of section 77, that is registration, shall apply to a company acquiring any property subject to a charge. So if there is a company which has acquired Jet Airways and Jet Airways has assets which were already subject to a charge, so again I will have to file the charge documents, or any modification in the interest rate or any changes will again have to be filed. So section 79, 80. Section 80 is date of notice of charge. Here notice means knowledge. Notice means knowledge. Okay. Now someone is asking, can company take a loan again on the same property? Yes. And all these provisions are with respect to that only. I'll give you one more example on that. Okay. So pay attention. Section 80. Date of notice of charge. So let's say there is a property. There is this property. This property has already been secured and registered with bank 1. So it has been successfully registered. Then I come in on the same property, it is going to be kept as security. So I say, okay, fine, I am ready. Now he is the first guy, I am the subsequent charge holder. Now what happens, can I, and this has been registered, okay, charge has been registered. Can I tell that I was not aware that the earlier charge documents are registered, all these details were already been done, I have no knowledge only? Can I say that? So the answer is, law is assuming and deeming that you already have the knowledge. Moment this was registered, the world should know about it. It is assumed that every person has the knowledge of the charge from the date of its registration. So what it is, that any charge which is created on a property, any person acquiring such property, so I am acquiring a property which is already subject to a charge, it is deemed to have knowledge of the charge. So any person will have assumed that he must be knowing that there is already subject to a charge, because he should do the necessary investigation, due diligence. And if you go to see, now the next section is section number 81. Section 81 talks about register of charges to be kept by the registrar. So the MCA portal already maintains, and you can go and check all the charges of any company. So there is no excuse that you did not know that the company has kept a property as security. So let me give you an example, okay, where I'll take you through the site. Now can you see the screen? So this is through my portal. Okay, now where I'll try to take you through this. Okay, here you go to MCA services. In MCA services there is a given called as company master data. They will be giving you company or company master data. You have to click on that. Moment you click on the company master data, then put whichever company name you want. So let's say if I want to know the details of Reliance Industries, okay, or Reliance, let's search. So all the companies Reliance, so this is the MCA portal. I go and I want to know about Reliance. Okay, all the Reliance entities will come up. So let's say I want to know about RIL, okay. Now I want to know about Reliance Industries. So I come to know, have to put the this details. Moment you go there, you will get the complete details of Reliance Industries, and whichever company you want, you can search it in the similar fashion. The entire detail, the SIN number, the code, how much capital do they have, authorized capital, paid up capital, where is their office? Office is in Nariman Point. Okay. Now the details of the charges will be given. Now charges are, they will give you when how much amount of loan they have taken, what is the date of creation, date of modification, and the status. So we would come to know, and if you pay 100 rupees, you will get extreme detail, which property, and all those entire details will be given. So interest and charge can be created on the immovable property, movable property, okay, all of this. Book debts also, so your debtors, the debtors are going to pay me. So against that I can take loans also, it is allowed. So all these loans they have taken and they've closed. So much loan Reliance Industries has taken. You just keep going down continuously. They've closed the loans also, and many would be open. So currently they have this loan of this much amount, loans open. So all these data you can get, and you can even come to know the director details, their DIN number, etc. Mukesh Dhirubhai Ambani. Okay, so all the details you will get. Like this, you can remove the data of any company and its charges. So this is what they're saying. ROC has to maintain a site with this. So this is given under section number 81. Quickly going to section number 82, talking about satisfaction of charge. What was satisfaction of charge? CHG 4, once you paid, you inform, and moment you inform to the ROC that I have repaid the loan, ROC will not register. ROC will give a notice of 14 days and asking the charge holder that this guy is saying he's paid the loan. Okay, and they will tell him within 14 days you come and tell us why we should not register the satisfaction of charge. Okay, the notice shall not be required to be sent if it is already signed by the charge holder. If the charge holder has already signed the document with the borrower, then we don't need to give a notice because he's already signed it. And once the document has been given, then CHG 5, ROC will give a certificate in CHG 5. What is the timeline? 30, 300, and after 300 days you can go to the central government to condone the delay. So for satisfaction of charge, 30 days, beyond that 270 days you get more delay, additional fees, and after 300 days from creation, then you have to go to the central government to pardon the delay or condone the delay. Now this was section number 82. 83 talks about power of the registrar to make entries for satisfaction and release in absence of intimation of from the company. So if the company has not intimated that the charge has been paid off, and ROC has sufficient proof that loan has been repaid, where a company may fail to send an intimation of satisfaction of charge to the registrar, then the registrar may, on receipt of proper evidence, will register the satisfaction of charge and will inform the affected parties within 30 days from the entry in the charge books. Means what? If satisfaction of charge under 82 is not intimated, and ROC came to know later on that they have already repaid the loan but they've forgotten to inform us, so the ROC will then give a notice to them and register the satisfaction of charge. 84 talks about, now once satisfaction is at 82, 83, 84 will obviously be the sad story. Sad story is about in CHG 6. That whenever a receiver or a manager has been appointed with respect to the property, he has to intimate to the ROC that he has been appointed. When he ceases to be appointed and his tenure is over, again he will have to inform. Now coming to 85, company maintains the entire details in CHG 7. This will be kept at the registered office, and it is open for inspection. So anyone wants to see the register of charges of the company, it shall be kept open for inspection during the business hours by any member or creditor without paying the fees. And if you are not a member or creditor, then fees can be taken from you in case if you want to inspect. Maybe you might be a prospective investor, etc. Then you have to pay the nominal fees. Penalty is being given for contravention. 86 and 87 talks about rectification by register and condonation of delay. Again, first, if within 300 days satisfaction of charge is not informed, then you can go to the central government, can register that, can condone the delay. And if there is a omission to give intimation that we saw, and or if there is a misstatement in any of the particulars. So if you've given a wrong information and you want to correct it, then you go to the central government under section 87 and you can register it. To the central government, the form is CSG 8. And if the central government deem fit, they will pardon the delay, or if it is rectification required, it will rectify it. So from here we finish section number 77 to section number 87. Now we're talking about charge, fixed and flotation. Now these are all small little concepts, but very, very important. Okay, very, very important. So section 77 to 87, we have completed all the sections in depth. So hit the like button if you understood everything. Now going to the concept of charge. Okay, fixed and flotation. First, what do you mean by fixed and floating charge? Quickly I'll tell you. Fixed is when you fixed it on a specific property which is identifiable and non-fluctuating. For example, if I've kept it on a building, that's it. That this building has been kept as security is called as fixed charge. So whatever you must be having knowledge is a fixed charge. A fixed charge, the security is fixed and identified. A fixed charge is created over assets which are ascertained, definite at the time of creating the charge, such as land, building, plant and machinery, etc. Okay. When the loan is repaid, the rights will be transferred back to the borrower, and in case if there is a default, then that particular asset will be sold off by the creditor. Now let's understand floating charge. This is what some do not understand, and I'll give you examples which you will definitely understand in complete details. Okay, so I'll explain what is pari passu also. Now coming to floating charge. Floating charge is a charge which is not fixed. That means it's floating. It is not on any specific identifiable asset. It is on assets which are of fluctuating kind. Example, stock and trade. So let me give you perfect examples of what. So we draft documents of floating charge. So let me explain. So let's say nowadays what happens? Companies don't give land and building, plant and machine. They take smaller loans. Let's understand. Okay. So let's say there is a company, and company in their shop or in their godown or in their warehouse always have goods worth 1 CR. Always goods are kept of 1 CR goods. What does company do? Company goes to the bank and tells the bank that give me a loan. Okay, give me a loan. Now they ask for security. In the security, what they say, see, land and building and all that we don't want to put, or it is already mortgaged, but this minimum stock of 1 CR is always kept. So this I can keep my stock in trade as security. Let's say the bank and the company might be having good relations, and the loan amount is also not much. So the bank will say, okay, fine, better than unsecured, give a floating charge, it's fine. Now what happens? Goods are kept. Company can deal in these goods. So one lot will go, a new lot will come. So here there is a constant movement of goods. Company can deal in the goods. Company can deal sell these goods also, but when they are selling these goods, new goods come. So because they know that at any time they maintain a minimum stock of 1 CR. Banks take some rights of inspection also, that every time our person can come, investigate and keep it. So this is a floating charge. Now what happens? Why floating? Because the goods are not fixed. Lot numbers can keep changing. One company can deal in the assets as they want. Now, when does this floating charge becomes fixed? Now let's go to the next thing, okay? Now when does floating charge become fixed charge? Now obviously understand that this is continuously movement of goods are there. Okay. Now continuous movement of goods must be there. Okay. Just a sec. I'll just have to fix my app. I'll just give me 2 minutes. Okay. So I will still speak. I'm just giving my. Okay. So now let's understand. What happens is, company keeps dealing in these goods. One lot goes, new lot comes. So this is a floating charge. Now when the company defaults, let's say you realize that the company started defaulting in the EMIs, the bank is going to say, now stop this goods being removed and all this. They will say, stop right now, no new goods will remove. Whatever goods are there in the godown are now mine, I will start selling. So this is called as crystallization of floating charge, where now this floating aspect, this movement will stop. This will happen when there is a default or there is some violation of the terms and condition. In such cases, the crystallization of charge will be there. So crystallization of charge is a process when the floating charge converts into fixed. Now when does it get into fixed? Obviously when it is into liquidation, or the company ceases to carry on business, okay, and the receiver has taken possession of the assets, or on happening of any specific event in the deed. If you violated, you've done some wrong thing, then the bank will say, stop the nonsense, all this floating. Now it will not float. Now it is fixed. Whatever assets are there, I will take these assets, these lot numbers and sell. Now tell me one thing, between floating and fixed, you would like a fixed charge or you would like a floating charge in your name? If you were the creditor, a creditor should opt for fixed or floating. Can you all message? Now obviously now when there is a, let's say, default liquidation, first the fixed charge holders will be paid and then the floating. So obviously it is always better to be a fixed charge holder. If fixed charge holders are repaid, then only the floating charge will get crystallized and then they will get paid off. Clear? Now okay, now let's see, what do you mean by pari passu rights? Pari passu rights means what? Sometimes if this is the building and there is Mr. A and there is Mr. B. Now Mr. B doesn't want to be the second guy, because what happens if this goes into liquidation, first A will be paid off, then if the money is left, then B will be paid off. So let's say if this was a 10 CR loan and 1 CR was given to him and 1 CR was given to him. Okay. So as per TOPA, doctrine of priority, first full 1 CR will be taken by Mr. A. Then Mr. B will come in and take the other CR. In simple. Now see what happens. If this building was destroyed and its value became 50 lakhs. Now question comes, who will get the money? So as per doctrine of priority, first this guy will get. So he will get 50 lakhs and this guy will get absolutely nothing. Now after knowing this, would you ever want to be a subsequent charge holder? After knowing this, would you ever want to be a subsequent charge holder? Yes or no? Obviously not. So what is a remedy for this guy? This guy at the time of the loan agreement only, he will tell no, I want pari passu rights, I want equal rights with this guy. Okay. So if there's 50 lakhs, 25 lakhs, 25 lakhs will be distributed. I want equal rights. Now for equal pari passu rights, obviously the party one, the charge holder one, has to agree. And to make him agree, you will have to convince him, give him higher interest rate, some kind of benefits you will have to give to this first guy to allow someone else to be on his same footing. Maybe he might realize that it's a 10 CR property. What are the chances that it will drop to such a low amount? So he might agree to a pari passu right, provided he gets some benefits. Clear till here? Then someone has asked, what if a company is a OPC? Can they get floating charge as there are less possibilities that OPC has a higher value of stock? Yeah, so even OPC is just a normal company. So we are all talking about companies. So there is no distinguish between private, public, OPC here. Okay. So these are all applicable to all companies. Then it is different from hypothecation. So answer is, this is hypothecation what we have done. Okay, so this is a hypothecation. What is the difference between hypothecation? It's going to come in some time. Hypothecation is when the goods which are kept as security is kept with the borrower only. Like the go down example. Company has kept the goods as security with the bank, but the goods are kept, the possession is kept with them only. That's called as hypothecation. Normally in pledging, you transfer so if I go to take a gold loan, I give the gold there. So there is movement of goods. I give it to the lender as security. But if you see, most best example of hypothecation is cars. When cars are taken on loan, the bank has rights over the car, but the car is kept with the borrower. Clear till here? Does it happen in practical life or is it just theoretical? All of this happen, everything in practical life. All I'm giving you is practical examples. Okay, so even hypothecation, you go and see any car loan is an hypothecation. Banks, we have drafted documents and in professional also you will see drafting of documents are there for hypothecation of goods, where companies keep the go down, whichever they have in the go down, that they keep it as security and take loans. They just need loans. Okay, so they try all their level best. They can do whatever they want with their assets. Now, so these are all the sections. Now some key terms that I'm going to come across and then we are done with the chapter. First, what do you mean by interest? Interest means a right, and lien is a right to lien means to keep forceful possession of an asset till the lawful amount is repaid. For example, you are not repaying my amount, so I will just keep your phone with me and I will say that I have lien. This is lien. I'm keeping forceful possession of this mobile till a lawful amount is due. So that's lien. Now in Indian Contract Act, few terms, that is bailment. Bailment is a French word, has been derived from the French word bailer, which means to deliver. Okay, now bailment is a contract in which one person transfers to another person of goods with a contract that once the purpose is over, the goods will be returned back. For example, bailment is transfer of goods. Possession is transferred for a certain purpose. Once the purpose is over, it will be given back. That's bailment. I give this pen to you. Once you've used it, you give it back to me. So movable property, transferred possession for a purpose over, give it back. Now here, how is bailment coming in? Because I want to tell you the concept of pledge. Pledging is when you keep movable property as security. Okay, and you transfer the possession. You transfer the possession of the goods. For example, have you heard of gold loans? Muthoot Finance, the biggest gold loan company. Okay, so it is a gold loan. So you give the gold to the bank. So there is a transfer of possession but not ownership. So pledge is a kind of bailment. Pledge is a kind of bailment. So your bailment is transferring the goods to deliver the goods for a certain purpose. So here we are delivering the goods to him for a purpose, to keep as security. Once the purpose is over, that is once the loan has been repaid, it will be given back to me. Clear? So pledging of securities are there. Share certificates can be given. I'll keep it as security. Once I'm delivering it to you. Once I repay the loan, give it back to me. So that's pledging. Pledging is, simple words, keeping movable property as security. So pledge is a bailment of goods, transfer of goods to kept as certain security, and once the loan is repaid, it will be returned back. In hypothecation, what happens? Hypothecation is there is no transfer of possession. I keep the goods with me and I say this is only security, I am keeping it with me. So this could be the car is the security to the bank and the car is kept with me. Stock in trade is the security to the bank and it's kept with me. So that is called as hypothecation. In pledge, transfer is done. In hypothecation, transfer is not done. What is difference with mortgage? Mortgage is for immovable property only. Mortgage is covered under Transfer of Property Act. Hypothecation, pledge is only for movable property. Pledge, there is movement of goods. Okay, and in hypothecation, it remains with the borrower. Here it remains with the lender. So the goods go to in pledging gold loan, I give the gold to the bank. So I'm pledging it. And in hypothecation, I keep it with the borrower. Gold loan, car loans and housing loans. Mortgage, what do you mean by mortgage? Very simple. If you have an immovable property like a house or a building, okay, and I keep this as security to avail a loan, it is called as mortgage. So tell me one thing, if I keep this pen as security and I transfer these goods to you, it is pledge, hypothecation or mortgage? This pen has been kept as security to you. I transfer the possession of this pen to you and I say once I repay the loan, you give me my pen back. It is pledge, hypothecation or mortgage? So it is pledge. Second example, if I say that give me a loan, my car I'm keeping as security, I will keep the car with me, but if I cannot repay, then you come and take possession of the car and then sell. So in hypothecation, the rights of the lender is little less because he has to first come, get the possession and then sell. Whereas in pledging, he already has possession, so he can sell. So that is hypothecation. Third, if I say I'm keeping my land, my ancestral land as security, what is that term called? Mortgage. Concept clear? Okay. So pledge and this distinguish, very simple. So in charge covers immovable property. For immovable property, it's mortgage. For movable property, it's called as hypothecation if possession is not transferred. If possession is transferred, it is pledge. Now in transfer of property, there are some terms like mortgage. So transfer of property. Now this you do when you're doing EBCL TOPA. So there they go on to tell you there is a difference between, from TOPA point of view, transfer of property point of view, that is specific to those only. With respect to immovable property, the term charge there is little different. Mortgage. So when you're doing transfer of property, that is when you do the difference between mortgage and charge from there. Now let's look at the exam questions. Okay, and we've covered all the exam questions as well. So June 2022, what happened is while sanctioning, now these are the exam questions. Okay, so let's see if I was good enough in helping you out or not. While sanctioning the working capital limits, the rate of the interest has been fixed at a specified percentage above the bank rate as notified by the RBI. But later on there was a change in the interest rate due to the RBI notification. Lending bank insisted on filing the modification of charge. Decide if the claim of the lending bank is tenable. Now understand, you need to read properly, okay? While sanctioning the limits, the rate of interest has been fixed at a certain percentage above the bank rate notified by RBI. So normally the interest rates can be fixed as 2% plus the bank rate of RBI. So this was fixed. They will fix a percentage plus the bank rate. Now there was a movement in the bank rate. It must have increased or decreased. Do you need to file charge document, modification documents? Yes or no? I just want a yes or no. This was decided between the borrower and the lender. RBI changed the bank rate. For this, modification documents need to be filed. Answer is no. Why? Because modification is a change between the original charge document between the lender and the borrower. Now the lender and the borrower still have kept this rate only of interest. There is no change of terms and conditions between the lender and the borrower. They've already said as per the RBI reference rate, and RBI keeps changing its rate. So that's fine. So document need not be filed. In December 2020, they asked an encumbrance may be created by charge, pledge or mortgage. So then you have to explain the terms charge, pledge, mortgage, and in all these examples, whether a charge or a pledge or a mortgage, can I say that the property is encumbered? There is an obstacle on the property and there are certain rights on property which is created in favor of someone else. The lenders, yes or no? When I create a charge, I give the bank the rights. Now the bank will not allow me to sell the property. If there is a pledge, so I give the property to them. Now they will not allow me to sell. So there is on that asset, there is a freehold. It's not a freehold anymore. It's not that you can deal the way you want. Now you've given rights to someone. So there is a encumbrance, a kind of an obstacle created on the property. So you explain in your company law the section. So in any topic, wherever the section your charge comes, you have to write section 2 subsection 16 and then explain. Then in June 2021, they have asked, as a company secretary, explain the procedure for satisfaction of charge. So you need to know your form numbers, CHG. Which are the form numbers? Can anyone tell me? CHG 4 and 5. And which section? Section 82 and 83. Okay. Then similar thing they said, ABC has taken a term loan of 5 CR and given a property situated in Maldives. Can the company give the property situated outside India? Referring to the property. So you will write section 77 subsection 1 and you will say whether in India or outside India. Now again similar thing, they say that the office building was mortgaged which was in London. So again you will explain section 77 subsection 1 and that is it. We are done with the charge document, entire topic of charge. Now again I will meet you all tomorrow at 7 p.m. you all, and I will cover company law again. You will need to tell me in the comment section which topics of company law do you want me to take revision. There will be revision for all the chapters, all the law subjects including tax. Right now I am doing company law. In the chat section you all need to tell, in the comment section after this video is done, you all can put up which all topics you all want and how I can help you all. Second, you all need to download our app. In the description you will get our Telegram group, our WhatsApp groups. Go ahead and join it. In the app you need to download the app and put the batch code dream batch exe. So with that, you all will be added in the dream batch, and I personally monitor that for the revision lectures, whatever doubts you need till the very exam date. I will be there with you all. So got it. Deposits, debenture. So not in this chat section. Once the video is done, the comment section also, and any improvements or any kind of things you all need, let me know so I can, accordingly cater to that. So that is it for now. Thank you so much. Also, please share this video in all your WhatsApp groups and inform all your friends so that we have larger participation, and it's always fun, and try to inform your friends also of the lecture. That is it for today. Thank you so much. See you all tomorrow at 7 p.m.